Thank you, Igor. It's my great pleasure to be again here. I became kind of regular, coming every September, and really have to thank Igor and Susanna for fantastic organization of this event. As Igor mentioned, I'm on project. You can see on the bottom, this is paid. My trip to Dubrovnik is paid by Japanese government. This is the last year of my project. Let's see if I applied, but let's see if I have good luck. Maybe next year again, I can have it with the Japanese grant. So it's a project about electronic transport documents, and I had various stages in my project, and this comes to a kind of final stage, which started with ancestral model on electronic transferable records. Which means a kind of attempt to regulate at national level, because many issues remained unresolved, and the problem remained with lack of legal recognition of endorsement or possession in electronic form. If I knew that I would have 60 minutes, I would add a few more slides. I will start with my cow. A legal promise could easily be written down with black ink on white cow and still be legally invalid. The main reason we don't use such a method is that it's most inconvenient to have one's promissory notes feeding on green pastures. This is Kurt Grenfors, famous Swedish professor. Though one English scholar told me that this kind of metaphor was used by some English scholars as well. What is the meaning of this? I mean, this can help. Next slide can help. The law has never required documents to be on paper. There is no any law which would state that the documents must be on paper. Documents were on paper because paper was most convenient way of writing information. Once upon a time, I saw Hammurabi Code, which was in stone, engraved in stone, because there was no paper at that time. And this is again one English case. There is a document wherever there is writing or printing capable of being read, no matter what material may be upon which it is impressed or inscribed. So as Kurt Grenfors rightly said, you can have a valid promissory note if you write with black ink on white cow. That would be valid document, but of course you cannot, it's inconvenient, you cannot take it to bus or to train. So for convenience, paper has been used for centuries. Okay. And yes, because Igor gave me more time, I will give some introduction to possession problem, something which happened before. I started actually research on this area of law 90-some. There was electronic data interchange at the time. And then that was the first stage of legal action in e-commerce. So what was the first stage of legal action? Was about legal recognition of signature, electronic signature. So a number of countries have introduced special laws on electronic signature. That was one way, one action. Another was revising civil procedure. Because the issue was whether this kind of electronic record would be admissible in court. This is of particular importance in common law countries, because in common law countries they have special rules on evidence, on admissibility of evidence. In civil law, we don't have such strict rules, so it's more about weight. At the end, it comes to the same point, but in common law, they have very strict rules. For example, hearsay rule, that if there is a hearsay, that evidence would not be admissible. And that was issued with electronic records. Is it hearsay or not? So many jurisdictions, including UK, United States, have revised the civil procedure rules to allow use of electronic records. So this was resolved in the first stage. And you know that e-commerce is working, and that was a real revolution with computers and IT. I mean, my feeling is that history became, how to say, accelerated. many things, history started to move faster, at faster pace. Now, I wrote my first master thesis on typewriter. And now if you ask youngster, they would not know how to use it, typewriter. There was last year, there was on Japanese TV, they gave this black phone telephone to children. They didn't know how to use it, but they were just looking, what is this? So that is how history has changed. Now those typewriters that I used to write my master thesis is a kind of history museum. My next stage was another master thesis in Japanese, which I used a so-called word processor. Word processor, which was kind of first stage before computers were invented. It was very convenient because it had this cut, copy, paste. On typewriter, you don't have that. So it was really stressful because I type it myself. So you make a mistake in typing and then you turn paper and after a few attempts, you go around to make it work because you're under stress. Now it's young generation, it's very convenient. So with word processor, it was possible to recognize these Chinese characters, which was very important. And then it was this function of cut, copy, paste. Memory was very, very, very little, very small. And next stage, when I started, when I returned to my country after Japan, then there were computers. Oh, something new. Of course, there were big computers at that time. And then e-commerce was functioning, but there was one issue which remained unresolved until today. That is about possession, about endorsement. Endorsement is an Italian invention from Middle Age. That's how it's called in endorsement, indosso, on the back. Instead of carrying money on horse carriages and being at risk to be attacked by local mafia, Italians invented that you put it on the piece of paper and then you transfer the rights just by writing on the back, indosso, or French call it ando. That's why there are two words, endorsement and endorsement. And that was the issue that remained unresolved by e-commerce, the most complex issue, because it related to transfer of rights, to transfer of possession. You can use it, so it's the technology is not problem. So that's why the UK Law Commission called it possession problem. Possession problem, which means that this has not been legally recognized by law, by English law or by any law. So there was an issue how to solve the problem, because, of course, you can solve the problem and the electronic bills of lading were operating in practice, but on contractual basis. You would sign a kind of rule book like Bolero rule book, which is kind of central registry. And you sign, when you become member of Bolero, you sign a contract that you're bound by rule book. This means that you're not going to challenge legal validity of electronic transfer of rights. So this was kind of first stage of development of electronic possession, we can call it like that. It was based on contractual obligation. And this worked in practice because it's freedom of contract. You agreed not to challenge, and that works in practice. The problem is that Bolero is closed system. It's not open. That makes it different from bills of lading. Bills of lading, anybody can use, but Bolero, it's closed system. It does not work outside the system, and it's expensive. You have to become member, and it's kind of club of rich club. People, large companies can afford, but small companies cannot afford. Next stage was blockchain, which is still working, but not widely used. Again, there is an issue with legal recognition. A blockchain is decentralized. So it's basically, it can be open, it can be closed, in both, there are both variations. But still the problem remained with legal recognition of possession. So the problem is not technology, because technology is easily, you can transfer rights. You can also prove that there was no interference. You can make, by security measures, you can, of course, always there is a risk of hacking, but a risk exists in paper as well. Just people expect when there is something new that is supposed to do better than previous way of doing things. But to be frank, it's much easier to falsify paper bill of lading than electronic, Because I used to work for shipping company. I've seen hundreds of bills of lading. I never pay attention to signature of master, because you can easily you just use your left hand to sign, and you can of course there is a problem actually with documentary fraud. Books are written about that. So it's not 100% safe, but technology has ensured that kind of reasonable level of security. And that is what business requires, not absolute security. You can't have absolute security. The problem is with law. So the technology, no problem. Problem is the law, because the law is still bound by this tradition of document of title, that what are document of title, and how they are transferred in practice by endorsement, which means on the paper. And how you can replicate endorsement. That is an issue. And that endorsement means also transfer of possession. Okay. And that's many legal systems, basically very few. Americans very, very fast. In America, there is no problem, because they have revised Uniform Commercial Code, recognized electronic transport documents. We have it in code, 2003 revision. But many other jurisdictions were late in legally recognizing electronic documents. Because that is also now, Japan is under construction new law, and drafter said we cannot have possession in case of intangible documents. So you have to create something else. We shall see that the English have decided to keep possession, and that's a kind of exception. Most other jurisdictions are taking different way, and I'm going to explain during this presentation what other jurisdictions have done. Okay, and we should start maybe with very basic thing, explaining what are documents of title. The rights represented by document of title are embodied in such document and derive from the lawful possession of the document. And there is a German saying which is it hits the point. Das Recht aus dem Papier folgt dem Recht am Papier. The right on paper follows the right from the paper. So if you have the right on paper, if you have it in your hands, you are lawful holder. You have the rights which are embodied in the document. So in case of bill of exchange, you have the right to receive the payment as stated in bill of exchange. In case of bill of lading, you have right to receive the goods when the ship arrives at port of destination. You have right to sell the goods in transit. This can be also used as a kind of security instrument for letter of credit. Bank would be kind of pledgee by having bill of lading. Bank has certain rights, because the bank is not lawful holder unless it's named as holder, but bank has a kind of deposit pledge. So basically, if you cannot pay, the bank will not give you bill of lading. Then you cannot get the goods from the carrier. So the possession determines who is entitled to the rights that are stated in the document. Okay, and something which was actually first mentioned in the Rotterdam rules, right of control. So basically, this kind of right guaranteed by possession means actually right of control. You are in position as a lawful holder to transfer the right. You can make changes of consignee. If the buyer will not pay you, then you give instruction to the carrier: don't deliver to that person, deliver to someone else. Under condition you have bills of lading in your hands, because once you transfer bill of lading, you are losing your security right. Okay. Yes. Replicating possession. Paper documents are capable of playing functions. They functions not because they are on paper. So it doesn't matter if it's on paper or not, but because of what they represent and are capable of doing. Electronic documents do not have to perform the function that's important of paper documents in the same way. What is important is that they achieve the same effect, because it's impossible. Of course, you cannot You cannot endorse electronic document because it's an electronic record. You cannot have endorsement, but you can still transfer the rights in a different way. The technology allows that. And then that was an issue. Is it necessary to find an electronic equivalent to possession or an electronic equivalent to the functional possession? And this actually, I will return to this point. This will be also, this was dilemma when Amstel model law was drafted, and there was discussion which one should be replaced. And we shall see that English law goes for first, equivalent of possession. So they retain possession as the main concept. All other jurisdictions have selected the second one, equivalent to the function of possession. And usually this is called exclusive right of control. Exclusive right of control, which serves as a functional equivalent of possession. And that's what is important, to replace the function, not necessarily to use the same terminology as we shall see why English have done that. There is logic in there is rationale. And we come to the key document. I think I mentioned it in one of questions on the first day. Amstel model law, electronic transfer of records, a very important model. Of course, this is model law, this is not legislation. And it requires action by national legislators. So far, 10 countries have adopted laws based on this model law. This model law is intended to enable transferable trade documents to be electronic term. This is kind of new term, trade documents. That is how it's called English law, Electronic Trade Documents Act. And it's a bit ambiguous, because what does it mean, trade document? In civil law, we have a very clear idea, because we have a concept of wertpapieren, documents of value. And these are transferable records. Not all of them are trade documents. Check is not trade documents. But those that are used in trade, like bills of exchange, like promissory notes, like bills of lading, warehouse receipts, these are trade documents, documents of value. English law or common law has a different approach. Common law has a different classification. They make distinction between negotiable instruments and negotiable documents. This kind of distinction does not exist in civil law. In civil law, there is one concept which covers all these kind of documents. Because this is different logic of civil law and common law. It comes from the nature of these legal systems. Common law has preference for narrow piecemeal approach. That's why they don't like good faith. In civil law, without good faith, it cannot operate. It's key concept. But English law, common law has preference for concepts like mitigation, promissory estoppel, misrepresentation, which are all second alter ego of good faith. All these concepts in civil law are covered by this is good faith. But English law has this kind, because English law, common law by nature is different. Instead of having this kind of abstract concepts that cover many issues, English law starts from kind of individual concept like precedent, like case, and then you develop it to cover many issues. In civil law, the rule would be apples are green, and then each particular apple is green. In common law, it's opposite. This apple is green, then other apples are green. Induction and deduction. This is different logic of civil and common law. This is also has a kind of effect on different nature of this kind of documents. So that's why we will see that there is a confusion. We shall see in English law that there is confusion about what are trade documents. And I have a serious objection to some of documents that are included in this UK Electronic Trade Documents Act. Okay. So the core principle of this Amstel model law is an electronic transferable record shall not be denied legal effect, validity, or enforceability on the sole ground that is electronic form. Very simple rule. And this is the way to recognize legal effect of electronic trade documents. It's this kind of functional equivalence principle, which was developed even earlier by Ancestral. There is Ancestral model on e-commerce 2016, if I remember, and one of the principles was functional equivalence. Instead of creating a new legal framework for electronic documents, already existing document that apply to paper documents is expanded to cover electronic documents. So this is the same logic in this model law. As I mentioned, Americans already have adopted in UCC, I think 2003. It's section 7106, which is entitled Electronic Documents of Title. So in very practical way, very pragmatic way, Americans have solved this problem, and it works in electronic environment. And my guess is that this UCC law has exercised influence on drafting of Ancestral model. I know one professor, Henry Gabriel, who is involved in Ancestral, and he was also involved in drafting UCC. So my guess is that he probably influenced the drafting of Ancestral model law in very similar way as UCC. So the flexibility and lack of rigid regulatory requirements provide opportunity for success. Actually, these are words of Henry Gabriel. He was very, how say, favorable, because probably he was one who drafted this law. So it is does not provide some very complicated, that would make difficult adoption application. It try to be as simple as possible. And this is the way how laws should be drafted. Try to make it simple. I think last time I had some story about Rotterdam rules. Rotterdam rules are too complicated, because the particular people from practice, they don't like complicated rules. You have to make it simple, that everybody can understand. Okay, and that's, I think, Ancestral model law has achieved that objective. So these are main principles, and I think first two of them are already present in this Ancestral model law on e-commerce 2016. A principle of technological neutrality. That is very smart way, because, as I mentioned, the history is accelerating, technology is developing at fast pace, and instead to be bound by particular technology, you make it open. So this is technologically neutral. So any new technology that might appear would be covered by these rules, including blockchain. Blockchain actually came just a little bit. I think that's partly problem of Ancestral model law, because timing was bad. It was 2017, and blockchain started actually to be used more widely in practice only after this. So I think this model law did not take into full account blockchain technology. It was just before blockchain technology started to be used in practice. And the one that I already mentioned, principle of functional equivalence, that replicating the functions performed by paper document in electronic form. So basically same principle as in Ancestral model law 2016. Instead of creating a new legal framework for electronic documents, you basically expand already existing to cover electronic documents. And right of control, new concept. And I think I believe that first legislation that adopted this concept was Rotterdam rules. They have provision about right of control and lawful holder of bill of lading. Right, lawful holder bill of lading, the person who has bill of lading in his hands is in control, and that is something which is related to possession. Because right of control, this is a bit how say difficult to distinguish. How we can distinguish control and possession, because these are different concepts. It's not the same thing, but control is essential ingredient of possession. If you have possession, you have control. Okay, but you can have control without possession. So it's not the same thing, and that remains actually something which may need further research. That's something I gave myself as a kind of homework to try to explain the concept of control, because control is used in different contexts and can mean different things in different jurisdictions. So there is a need for clarifying or harmonizing the meaning of control, because at the moment there is no clear. If you read UCC, you will see control mentioned in different contexts, completely unrelated, but the term is there, control. Exclusive control. So we go a little bit further. It's not control, but exclusive control. The person in exclusive control of electronic transferable record is in the same position as the holder of a paper document. So when you have exclusive control, and we shall see how this can be achieved, you're basically in the same shoes as the lawful holder of bill of lading. You have the same rights: right of control, right of disposal, a right to receive the goods, right to transfer your right to someone else, right to give instruction to carrier. Exclusive control is devised to address requirement of possession to exercise control of specific electronic record in a manner that is functionally equivalent to possession in law. So that is the main idea of UNSTAR model law, that exclusive control should serve as a functional equivalent of possession. So it's not to replace possession, but to replace functional possession. Possession implies exclusivity, because you can, of course, you can have in some cases joint possession, but that's these are exceptions. Husband and wife would have joint possession. You can have a partnership, can have joint possession. But in this kind of issue, it's when you have, as a lawful holder of bill of lading, you're exclusive holder of right, nobody else. Bill of lading can be issued in several originals, but this does not mean that there are separate rights. The one who comes first would have right to receive the goods. Of course, there is a risk of abuse. That's why UCP rules, they require full set of bill of lading to avoid the risk that I still don't understand why now we need several originals. And with this, actually, this would disappear. There will be no several originals. There will be only one. So probably this would have impact also on drafting of a new revision of UCP. They will have to take in consideration electronic documents. Possession implies exclusivity exercise, which corresponds to control under the principle of functional equivalence. Exclusivity provides clarity to control. So this means it's not control, but exclusive right of control. And this is functional equivalent of possession. And this is very important. And this was also, can't say copied from UCC, but obviously UCC has exercised strong influence in this respect, because UCC has special rules about integrity and singularity. Transferring control requires identification of person to whom electronic document was issued or transferred. Without that, without this element of integrity, the system cannot work. And this must be reliable. And as I said, this reliable means reasonably reliable, cannot have absolute security. Fundamental condition is that the method employed to fulfill all requirements regarding identification and control of a record must be reliable. And technology has developed various mechanisms to ensure. In blockchain, it's very complicated. You have it numbers, algorithms, you have the mathematics to ensure that nobody else can access something that one person has kind of a private key. Private key is a concept that is used in blockchain. A reliable method is used to ensure the holder's exclusive control of electronic transfer record. I think this should be clear. It's an essential ingredient of the whole system. The term that was used by UNSTAR model was singularity. Before it was uniqueness, I think, but now they have changed a little bit. I'm not sure exactly, I can't remember what was the point of changing this terminology, but this singularity requires reliable identification of electronic transferable records. So this is a technology side that ensures that integrity of the system, which is basic requirement. Without this, the whole system would collapse, cannot work. And then we come to something which is probably the central part of today's presentation, is about national legislation. And there are some legislation adopted before Amsterdam model law, mentioned UCC. Germany has a very simple rule, but not, I would say, not very efficient. Require kind of legal recognition by the government, and as far as I know, nothing has happened in Germany. So probably my guess is that Germany would have to adopt new legislation based on Amsterdam model law. South Korea is saying they have kind of very complicated system, with involvement of the government. And as far as I know, Peter is here to correct me, it's not used in practice. It's in the commercial code, same as in Germany, but not used in practice because it's not really practical. And what Amsterdam model law is something which is feasible and practical and acceptable for business. After Amsterdam model law, several legislations have adopted around the world, 10 so far. The last is Timor-Leste, is Timor. France has adopted law that was important to move in June 2024. I think Patrick mentioned this. UK, that's very important because UK is very important. English, it's England and Wales, not Scotland. Why? Because in one report, I think you asked me about what I mentioned, that 80% of bills of lading are governed by English law. That was stated, I did not create that figure. I found it in the report, which was part of a law commission report. That was statement by ICC UK. So they say that 80% of all bills of lading are governed by English law. So that's why English law is so important.
In the world.
In the world, yes. I think I mentioned to someone yesterday, I used to work for a shipping company. I can't remember any other jurisdiction. It was always English law, completely unrelated to England, but always English law, English court. I think English are making very good money on this.
I don't want to offend any Scottish people, but the term Great Britain includes Scotland.
Yes, of course. Actually, the name of the law is UK. But Scotland decided not to be part of this. I don't know the reason.
It was a term when in 1707, when Scotland joined the England, under one monarchy, as it were, and that's when the term, great means extended. So Britain extended territorially, not in other regards. But an interesting aside, I'm enjoying, carry on.
Yeah, I think I mentioned that my book will be published next year. Okay, I have to market my book a little bit. And I mentioned to Ridian when we are talking that I compare British Empire to Roman Empire in my book. In what sense, what is legacy of Roman Empire? It's Roman law and Latin was for a number of centuries lingua franca. What British Empire left as legacy is the common law and English as lingua franca. So there is a parallel thing, and this became particularly after expanding and becoming one country with Scotland. That is a period when England, UK expanded its influence, because it was before it was kind of most of these cases were governed by civil law. In UK, in the English Admiralty Court from the continent. Only after that, gradually, common law prevailed.
There's a significant shaft of civil law. I mean, Judge Coates, married divorce, parents, and of course, the Admiralty, because the Admiralty judge would actually possibly have an intestacy in the morning or and then in the afternoon resolve a collision case, something like that. Yeah.
The code of wives, wills, and regs.
And because the earlier structure of the High Court, if you go back, we had a PBA structure, probate, divorce, admiralty.
Yes.
That affected the civil strand in the common, which and of course all education until the start of the 19th century is based on civil law. So you have BCM in Oxford, Bachelor of Civil Law.
Yeah, particularly with development of trades and
Changing the direction of this sense.
yes, okay, we can extend because we have 60 minutes. Because actually, with discovery of America, that put England, UK in the strategic position, and from that moment, UK started to develop because it was kind of a backward country in matter of admiralty law until that moment, and then suddenly became in the central position. And there was a tension because this admiralty case became very lucrative, and there was a competition between admiralty courts and common law courts. So it was, and many of these kind of changes that happened later are part of, and of course, this became part of common law. Admiralty court became part of common law. Okay, this was excursion, sorry. In Japan is now in the process, yes?
Yes, I'm sorry. Did you say that Scotland was excluded from?
Scotland, Scotland is not part of this law.
Do you know the reason?
I don't know exactly. I would,
They do have legislative competence. I mean, Scotland is devolved, and that's the Parliament and has a constitutional trial. It would be very surprising, for Scotland not to be. It's because it's international commerce, but just as Wales is ridiculous because the UK is increasingly becoming fed in its governments. And certainly Scotland has greater legislative competence than Wales. But in matter, for example, international arbitration, the like, they will follow, and there's a rating. So we have joint, usually when these things are considered for reform, the Scottish Law Commission will join with the English and Wales Commission and take joint consideration. So in international matters, they've been very much going with the mainstream, but with national health, road buildings, and the like, they resolve with that. So significant development.
Yeah, I guess it's kind of political reason they want to have kind of independent, and there is that kind of mood in Scotland. And it's a little bit different legal system. It's kind of mixed. It's not purely common law. And Japan is now in the process, and we expect by the end of the year, Japan will adopt law which will be based on ancestral model. They want to align with the international community, as they call it, and they want to stay outside. And they were very clear that possession is not acceptable. Possession is not acceptable because it contravenes civil law rules that only tangible goods can be subject to possession. And this is intangible, so they would already they use the concept of control. In the draft, it's still in the draft stage. So I mentioned a few times UCC, Uniform Commercial Code of United States. It's Section 7, revised 2003. And it mentioned it has special term that introduced electronic document of title. So it was a very practical way to solve this kind of complex issue. The Americans can be very pragmatic when drafting laws. So they have taken very practical approach, electronic document of title, and then you have legal recognition. There is no doubt under American law that electronic bills of lading are legally recognized. So this is quote from Section 706A, which is most important. A person has control of an electronic document of title if a system employed for evidencing the transfer of interest in electronic document reliably establishes that the person as the person to which electronic document was issued or transferred. Okay, and then provide for control as a substitute for possession. So they accept something which I think is the most logical control, because even if you use possession, it will come at the end to the point of control. And B of the same section, what I mentioned that this probably influenced provision about singularity in ancestral model law. They have provision about reliability, under which control can be exercised, about this kind of security to ensure that to ensure integrity of the system. They also state what are trade documents. That is something that I'll come later. So it's bills of lading, bills of exchange, doc warrants. They have some other concepts that are not mentioned in English law or in European law, French law. Singapore is very fast and they are very active. They used to have Electronic Transactions Act 2010, and they revised it in 2021, basically in line with Astral model law. They accept the concept of exclusive control of electronic documents, which is recognized as functional equivalent of paper documents. The main difference from Astral model law is that Singapore law provides that the method is deemed reasonably reliable if it's used by a system provider authorized by government. Singapore, earlier this year, I was 1 month in Singapore, and government plays a very important role. I'm not sure how much you are familiar with Singapore. It's not really a very democratic country. We have control, and the government wants to have monitoring of everything. So for me, this is quite natural that they want to have monitoring of this. So that should be in the hands of the government. We should see that English law is different. It's more private initiative, but in Singaporean law, they want to keep it for the government. France, that's important development because after UK and Singapore, France is another major country that adopted law very recently. It was June 2024, which is in line with Astral model law. Under Article 17, electronic transferable documents, Titre transferable electronic. And titre, this is actually a term that is used for documents of value, ver papir. In French, they call it titre. In Italian, it would be titoli di credito. So they are recognized as legal equivalents to their paper counterparts. So it's very similar. Actually, this UCC has played exercise influence on Astral model law, which now goes to other countries, spread to other countries. Article 14 defines transferable documents, and we can see that document is different. We shall see. I will compare later during the presentation. What are trade documents under French law, which is in line with titre. What are titre? Bills of exchange, promissory note, warehouse receipts, bills of lading, insurance policies. So these are considered as a kind of transferable trade documents, which carry certain rights with them. So in civil law, we don't have any dilemma. It's maybe there might be slight differences among civil jurisdictions because it's same as common law. It's not every civil law country is the same. But these are basically a typical ver papiri, a typical in Croatian with vrijednost in papiri that give you the right embodied in the document. So these are in civil law. That's it. And we shall see that English law and American law are a little bit different. Particularly English law, I have some objection to the list. Article 15.2 adopts concept of exclusive control. So again, it's based on Astral model law, defining holder of electronic transferable title as the person who has exclusive control over it. Implementation of system to monitor integrity of electronic transfer system is to be defined by decree issued by the French government. So there is a kind of parallel with Singapore. They want to have to be controlled by the state, by the government. So this is very, very fresh. It's 13 June 2024, but I think that's an important step that France has made, and it may have impact on other jurisdictions. Japan, of course, Japan is still in the process of drafting. They have working group. You may know maybe Fujita Sensei. He's a leading scholar Japanese. He wrote some books on Rotterdam rules, and he's chairing this commission. And you never know in Japan, there is politics playing business. If you have interest of business, of large business, it would be soon in the parliament. And if business does not show much interest, it will stay left for a while. So we can't say when it will go to the parliament. They call it diet. Parliament is diet in Japanese. The report, yes, it's currently it is called actually bills of lading, etc. And then later they added warehouse receipts. But at the moment is, I think they are influenced by American law because these are documents of title under American law, bills of lading and warehouse receipts. Probably later they would adopt some similar legislation for bills of exchange, promissory notes. As I mentioned, that's what is stated. There is a draft text which is available in English, and they use a concept of control. And the explanation that was given is that possession would contravene Japanese civil code. We can't use in Japan possession because possession is limited to tangible documents, and these are intangible. Possession cannot be used. So control is logical. Okay, and we come to now to this is actually UK. I forgot to mention it was supposed to be UK towards statutory recognition. Law Commission report. If you have interest to study about possession, it provides an extensive explanation of what possession is under English law. It's very detailed report by Law Commission. Obviously, they have consulted leading scholars and practitioners, so you can find a lot of useful information by reading this Law Commission report. Electronic documents cannot be possessed under current law and have same functionality as paper documents. To solve the problem, the easiest way is to amend existing legislation. There are two possible ways. One is that you have court, which would, because court can make same as bills of lading are now document of title because of liberal case from 18th century. Courts can make this kind of step, but courts were reluctant. It was we don't want to do it. And in one of these cases, English court said, while there were powerful arguments for extending possessory rights to intangibles, it was more appropriate for such a reform to come from the parliament after consideration by the Law Commission. That was a statement by judge. I don't want to do it. It's a hot potato is given to the parliament. Let's decide it by someone else. And we come to this Electronic Trade Documents Act. Actually, full name is UK, so it is United Kingdom Electronic Trade Documents Act, adopted just a year ago, entering force in September 2023. It was King Charles who signed this royal decree, royal assent. So it's now became law, and of course there will be some writing. Peter and myself, we wrote one comment on this law. It will be a chapter in a book, hopefully this year. And I'm also in my book also mentioned this. I gave a coverage of because it's very important. And what is important is not only because of this 80% of, but this the only country which decided not to use control but possession. Definition of trade documents, section 1.1 defines trade documents as documents used in connection with trade, transport of goods, and possession of the document is required as a matter of law or commercial custom, usage or practice for a person to claim performance of an obligation. Section 2.2 provides examples of documents that are commonly used as trade documents. So it's all kind of open list. Bills of exchange, promissory notes, bills of lading, ships delivery orders, warehouse receipts, maid's receipts, marine insurance policy, and cargo insurance policies. There are a few problems here. For example, under English law, only on board bills of lading are document of title. Receipt for shipment is not. Another document that I would include is a multimodal transport document, which has the same function as a bill of lading, but it's not recognized. Currently, it's not recognized as document of title under English law. And I have, of course, an objection to maid's receipt. Maid's receipt is not trade documents. Matrix seat is temporary seat until because it's issued by first mate, just to state what cargo was loaded, and this can serve as evidence. But you cannot transfer. It's not transferable document. You have no rights. By having matrix receipt, you have no rights. There is only one case from 1971 in which matrix receipt was recognized as document of title because there was a local customs in the trade between Sarawak in Malaysia and Singapore. But it was 50 years ago. As far as I know, in UK, English court has never treated matrix receipt as a document of title. So I think it's very strange. It's wrong. And if I'm in good mood, I will write papers on that. Why paid matrix receipt? I mean, it caused no harm. It caused no harm. It's just it was unnecessary, particularly when you have open list. There was no need to include matrix receipt in this. Okay, so what were alternatives available to Law Commission when drafting this Electronic Trade Documents Act? They could have exclusive control, which means that they adopt the concept from Astral model law, or extend the concept of possession to electronic documents. Law Commission was very clear that they follow the spirit of Astral model law, but they decided not to accept the term used. They've decided to use possession, which makes sense under English law, because possession is so important. There are so many cases, have huge body of law, which is revolves around possession. And if you want to have exclusive control, you would need something, interpretation or whatever. So there was a kind of tradition and huge case law that was supported the concept of possession. And they said, okay, we can just extend, because that is a dilemma, to have equivalent to possession or functional possession. And they decided to adopt equivalent to possession, to just extend the concept of possession to electronic transport documents, which can work in practice. I have no problem with that. And understand the logic, I think this is fine. Just I have a problem with the way they try to justify it. And I'll come later to that. Electronic Trade Documents Act provides electronic trade documents can be possessed and have the same effect as a paper equivalent. So this is functional equivalent of possession, not functional possession. So basically, you can have possession, electronic possession, if we can call that way. I think I had the idea to create a new term, electronic possession, which would be feasible. But of course, nobody used that concept. Possession corresponds to control over digital assets that enable the party in control to exercise possessory rights in the goods. This creates functional equivalence between electronic trade documents and paper documents. That was the logic, that was the rationale of Law Commission. And I have no problem with that. Whether that was necessary or not, so that's a different issue. I think they still could have exclusive control. I know that Roy Good initially, but later he retracted a little bit, and Michael Bridge. You can find in the report of Law Commission, they objected. They said control would be proper term. At the end, this would end up with control. I asked Roy Good, and he told me that he had in mind digital assets, not this. Okay, why is suitable? So what I already mentioned, well-developed English law applies to electronic trade documents. It would be easier without uncertainties about legal certainty. Something which was developed over centuries, you can now continue with electronic trade documents through functional equivalence. Possession refers to well-settled legal principle. I think that was main point. And there is something that I got kind of insider information from Louise Gulliver. Maybe you know Louise Gulliver. She's professor at Cambridge, and she was involved in Law Commission. She told me that if they would use the concept of exclusive control, it would take more time to proceed through the parliament. And if they would adopt the concept of possession, this is kind of non-controversial, and it's kind of fast-tracked. So it was kind of this kind of consideration to have faster adoption of this law. Yes, there was no need for a special procedure. And then what is difference between possession and control? Exclusive control, they don't treat as a functional equivalent possession. They use the term exclusive control, but not as functional equivalent of possession. Whether person with ability to control electronic trade document has requisite intention to possess, it will depend on the facts of the case. That is part of explanation given by Law Commission. And I found interesting this statement by Lord Parkinson. The system could transfer exclusive control of electronic trade document in a manner equivalent to trusting a letter in a person's hand, in which case the person does not have possession of the document since he does not intend to possess it. And I have a problem with this. I mean, it looks convincing, but document of title is not a letter. You cannot have this kind of parallel. What would happen if you give bill of lading in the hands of someone without endorsement, without legally transferred? You just give, I found it on the street. What you can do with that? Can you go to port and ask master, I want cargo? He's not lawful holder. He's not lawful holder. One thing is letter, which, okay, paper, but trade documents, document of title, they have special procedure of transferring. And the master will check that there is unbroken change on endorsement. So if you come and ask for the goods, the master would ask you, who are you? What is how you got your bill of lading? Unless it's bill of lading to bearer. If it's to bearer, is different. But bill of lading to bearer is practically never used. It's too risky. Normally, it's a bill of lading to order. So because that was actually attempt to justify why we are not going for exclusive control but possession. And they come to the point of intention. Of course, when you want to buy or to sell, obviously there is intention. You would not pay huge amounts of money to buy the goods if you don't intend to buy to only something you pay. It's without intention, it doesn't work. So I think this is a blockchain as an illustration how this may work in electronic environment. Exclusive control of blockchain can typically be obtained by in distance sale through payment against private key, something which was a payment against the documents. Now it's payment against private key. Private key in blockchain means that's a kind of exclusive control. So basically, when you have private key, you are in the same position as the lawful holder of bill of lading. So if you pay certain amount, which can be hundreds of thousands of dollars against private key, do you have intention to own something you paid for, or you would do it without intention? Of course, when you buy something, there is intention. There is a logical element of intention. So this argument that may not, it depends on circumstances. Of course, you can imagine that someone is donating whatever, but normally in trade, you are buying against documents and you want to have certain rights. And of course, you intend to have something that you paid for. Transfer blockchain has the same effect, just the way of transfer is different. Instead of transferring constructive, I didn't mention constructive possession. This is the key concept actually here. So when we talk about possession, it's about constructive possession, which means that you don't have actual possession, which you may get it when the ship arrives at the port of destination, you get your goods from the carrier. Then you would have actual possession. But normally, what is transferred by bill of lading is constructive possession, which means there is someone keeping as a bailee. Carrier is kind of bailee. Your goods on your behalf, And once, of course, the carrier does not have possession, because carrier does not have intention, can make this kind of problem with carrier. Carrier has no intention to have something because it's not here. He has imposition of custodian, he has custody. He keeps the goods on behalf of the lawful holder. For the carrier, it doesn't matter who is the owner. It's not his business. Bill of lading is not evidence of ownership of property. It's a right to receive and to transfer, not property right. In practice, you can transfer property if under certain conditions. If there is legal title, under English law would be at the moment the parties intend property to pass, and that is typically when you pay against the bills of lading. Under German law would be at the moment of delivery. So, but when you transfer bill of lading, that's moment of transfer of property, because it's kind of symbolic delivery. Under French law, it's just at the moment of contract, solo consensus. So it's not property right. It is constructive possession. And Louis Gulliver told me this is common law concept. We have something similar in civil law. We call it indirect possession. Indirect possession, that you have someone, you don't have it in your hands, basically same thing as constructive possession. You don't have it in your hands, but someone, you exercise your right of possession through someone, and that is the carrier. So this is the key concept, actually. So when we talk about possession, it's about constructive possession. Okay. Instead of transferring constructive possession by endorsement by acquiring private key, the new buyer acquires exclusive control that serves the same function as constructive possession. And this is a statement from this law commission report. Michael Bridge, it's a leading commercial law scholar in England, UK. Possession will have to be defined in terms of control anyway. And as far as I know, he did not retract it. He keeps this opinion. It's found in law commission report. So what are differences? Miriam Goldby, I'm not sure if you're familiar with this name. She is leading scholar. She's from Malta, but she's, I think, at Queen Mary now, a professor at Queen Mary. She's leading scholar on electronic transport documents. She published a fabulous book on this issue. And she published a paper with a Chinese colleague. And I found this very hitting the point. If under model law, a person asks, can an electronic transfer record be possessed? The answer would be no, but it can be controlled. And the law treats this as an equivalent to possession. Under English Act, Electronic Trade Documents Act, the answer would be yes, because they can be controlled and they control amounts to possession. So basically, it's the same thing, just they have adopted different routes. But at the end, it is the same thing. So I don't think there is any practical problem. I mentioned something about made receipt or whatever, but English law is, I think, it's functional, and it's a very important law that I think will be successful in practice.
Could I say, is it a change made necessary? Because I would not associate with lading with control, possession, constructive possession. But is it a change in language and possibly a certain change of emphasis made necessary by the change in the medium? Because it's hard to have the concept of constructive possession in an electronic environment. And therefore you have to find some way of engaging and coming to a close equivalence and calling it control, but not giving control a technical meaning, which historically is that. Is that a reasonable explanation of the necessary change made in the international instruments and national legislation, particularly the UK?
I think what can be done, I hope that will be done in English law and not English law. Courts may have interpretation which would basically come to the same point, equalizing this concept of possession with control, that it means the same thing. But this will have to be done. I think this will be done by.
I mean, obviously, courts, once this is translated into national law, it comes to the courts, and then it's a question of the interpretation of statutory provision, and they will be influenced by the law commission. But that, that would be part of the background of the legislation, and would probably follow the same process by the Commission.
Yeah, it could work both ways. The Law Commission had decided to stick to the concept of possession, and I think this can work with interpretation of the court that this means actually control. As Michael Bridge said, this is and Roy Good originally he said that this is actually about control. At the end, it is about control.
Yeah, but what is about control in the medium that we're moving into, and essentially it doesn't change. I mean, possession is fine if we're dealing with standard documentation and the historical way. But once we come to the electronic, you can't really possess.
Yes.
And therefore you have to find an alternative. You can control, except that I'm never control artists. My computer controls me. So I see it, it's a necessary step because of the change into the modern world. We can't live with historical ideas for reasons that we've been explaining.
Yeah. It is a bit strange that they use concept of possession, something you cannot possess in your hands. So basically, they're revising the idea of what this possession is. They are saying you can possess not only something which is tangible, which was based on current law, but they expand that also intangible goods can be possessed. I think this,
if in the very terribly, I mean, you can't physically possess something that's intangible.
Yeah. Yes, of course.
If you speak of possession, I mean, there's a mismatch between the word and the concept.
Yeah.
In other words, and what I'm really saying, I think it's quite an innocent proposition, which I'm guessing at, is this idea that control is the equivalence now, made necessary as a matter of language and media.
Yes. Eric, you want something?
Yeah, I was wondering actually if you came across also the bailment issue, because we know that bailment is a question of control. Possession. Oh, is it possession? Possession.
Yes, possession. Yeah.
Possession. Okay.
Yes, possession. The possession was used for bailing.
Okay, I do recall, however, that in developments regarding bailment, there would be that also issue. I don't know about controlling the disposal of the goods. Yeah, I just was wondering if bailment was actually discussed as a relevant aspect, or explaining why they stick to possession as Lillian is saying.
I can't because I can't remember really if law commission has used that concept. But yes, a carrier is a kind of bailey, no? It's a common law concept.
I think this debate is kind of interesting in the sense that it focuses on different aspects, but isn't it just a matter of terminology? Because I think that what these documents can do as trade documents is to give a right to get deliverance of whatever good we're talking about. And so to me, you can call it whatever you like. But I think you had a very good point that English cases, they do refer to possession. And that's why it's nice to have that in the new legislation. But the problem, of course, in international trade would be that although a bill of lading may have a choice of law for English law, this is property, and the choice of law in the contracts doesn't really resolve the problem of choice of law in property. Rather to the contrary, one would say that that's where the property is, rather than the choice of law in one of the contracts relating to the goods. And in that context, both the control and possession is kind of strange. And I'll just give two examples here. One is that the goods are stored on shore and sold before or after storage by means of the bill of lading. But then it's also sold in a market of that or something like that. And a purchaser with paid will get property in the goods. And then we'll see very clearly that it's not really controlled, because you can use the goods, although you have control over the bill of lading. And another example, in some jurisdictions, it's very important to have not only control, but it's even more important to have negative control. For example, if you wish to pledge goods in Scandinavia, you would need to, you don't need property to goods. We won't say you have property to goods, but we will say that it's important that you can deny the exercise of property rights of others. And will this possession or control or whatever, will that be sufficient in that context? And we'll go to it.
Okay, as I mentioned, bills of lading is not really about property. It's about possession, constructive possession mainly. Because who is issuing bill of lading? It is a master or carrier. And he cannot certify who is the owner. He can certify who delivered the goods to him for carriage and who is entitled to receive the goods. So for master, that is the only thing that matters, not who is the owner. And if you would deliver the goods to the actual owner without bill of lading, you're committing fundamental breach of contract. There was a case in Japan because there was the carrier has delivered the goods to person who actually owned the goods, but there was freight forwarder who were expected to get some fee for that. And he sued the carrier. Why you deliver the goods with, and I am lawful holder bill of lading.
But the interesting thing there is you deliver against the bill of lading because that is the contract. Right?
Yes.
So the delivery, I mean, the bill of lading doesn't give the right to transfer of its abstract possession into real possession. That is because under the contract of carriage, and what, as you rightly say, that's got to be done properly. And even if you're dealing with an expert forgery, an answer gives the degree, you still and interestingly, it's a breach of contract and also a tort.
Tort, yes.
Conversion,
yes.
The damages are the same, even if you send that to the contract. So, you know, this is, you're right. I mean, I'm obviously looking at it from fusion. The bill of lading is overworked, and people really get the wrong impression. And because so much is controlled, not by the bill of lading, but by the contract and the parties, the seller and the buyer. But it's abstract possession. And so you can actually, through the bill of lading, show goods to a potential buyer and so forth. But and the other thought I have in in the real world, listen again. I mean, how many deliveries are given against the bill of lading? If you're in trade, I mean, there's oil actually sold by markets. I mean, in 5 minutes, you could have 6 contracts, the same price. Nobody's dealing with bills, right? And yet, when a bill of lading contracts, and very often you get the end buyer and he's bought, and 3 months later, he discovers a defect, and he looks at lawyers, and people say, "We're standing. And then you've got to go back to history, you've got to go back and create a bill of lading almost it's after the event, just because it tidies up and all the legal analysis of it. So, you know, in this kind of picture, which is very historic, bill of lading and master and the like, you know, when you apply sales, I'm sure with containers, those containers are done under waivers, I suspect, under the rating, so all of this happens after the window. So it's, you know, the history governs the theory and how the courts deal with it at the end of the day. But the reality of trade, which is simply and if anything, the big message that goes out to people today is don't use it unless it's absolutely necessary.
Yes.
And it's virtually absolutely necessary because it's one of the documents that your bank would take. Because they have given, as a pledge, they've given constructive possession and that's their security, so we're back to the pawn and the like. So they would take, but the bank would need much more security than just that. The bill of lading is just one. But it means at the end of the day, if it's something they don't want to do, they can leave that ship at the port of destination and say, give us a car, or put it in our warehouse or in our tanks or whatever. So there's their security.
Yeah.
The good thing is saying, I've said
What would you say the bill of lading isn't necessary, and it isn't until things go wrong, until the wrong delivery has been made, and then there's been a few cases recently where delivery was without a bill of lading, and it was the wrong place.
absolutely. And that's the
Only one,
problem. It's not, you know, the force of that comes not through the bill of lading, but through the contract account.
Actually, that's
Yeah, what question do you have? So you own the house and you have the house in possession. That's classical rule of tangible. What about intellectual property? Or what about the electricity that you make electricity out of the sun and you store it in your unit for storage of electricity? So you own that electricity. So do you also possess it as intangible or not?
that's a good question. Okay, because it's intangible. Can you because I think electricity is actually excluded from Vienna Convention on International Sales because it's intangible. Yeah. So it's you have special rules for that. It's not classic rules on. Yes.
Right.
Zoran, you want?
You mentioned promissory notes and bits of exchange in the electronic form. One of the main features of these things is that in the event of default, you can protest it. The notary public can come to the bank, ask for payment failed, put a note, etc. How that works with electronic?
It's difficult. It's not.
I think we have to have it in physical possession. It's a
To make-
good old paper.
Yeah. People feel safe. People feel safer certainly.
For the notary to present it to the bank officer,
Yeah.
then bank officer checks the accounts.
Or you have to create some.
But the same can happen in electronic form, all that you are
How?
saying, because you can transfer the control of the electronic document by the private key, you transfer it to notary public, you transfer it, for example, the same for the LC.
So people go with the computer to the bank.
Not to the computer, you send the, so this is why it's so hard to understand, because it's an abstract idea of controlling something that you don't have in your hands. So if now I have a document, bill of lading in my hands, and I send it to you via blockchain, now you have it. You don't have it physically, but you have it. You're the only one that can do
But the
anything.
notary has to put physically a note.
Yeah, but the notes can be added to electronic documents, like endorsement can be added to the electronic bill of lading, like it's not on the back side of the electronic document, but it's kind of attached to the bill of lading. You can see the chain of the endorsement.
Send it on notary notes and
The chain,
change
the chain.
Yes, Eric.
Just the concept, it's hard to imagine because, but it's already happening. It's already the bill of lading. Now, I know there are a lot of skeptics, and that's why I'm looking forward for the debate, which I'm gonna. No, because we had the debate yesterday in February. But the fact is that in 2030, all the bills of lading will be electronic.
I'm not talking about bills.
Yeah, okay, but also,
Promissory
no, but
notes.
it's
In
the
the case-
same, it's the same.
Can I just finish my sentence?
Yeah.
Promissory notes and bills of exchange, in case of default, bring into the picture at least 3 more parties, which were never intended to be a part of it. Bill of lading is something else. It's evidence of cargo rights, etc., between the parties. However, nobody had in mind any intention that people like Notary Public or bank, etc., would have any contact with the promissory note at the time the promissory note was made. So you go to another public who says, sorry, I don't do electronic documents. What you're going to do then? You look for another public who does. And then banks say, we don't do it electronically, sorry. So what you're going to, how they are going to protest action?
But you have analogy with bill of lading. Look, when you're sending bill of lading to the bank, they have a control, but they don't have a title, because they don't want to have it. Because they don't want to enter into contract of carriage, because they don't want to be, for example, liable for the damage that was done by the cargo. So you split the control and the title when you send the BL to bank. It's not a part of the contract. It's completely outside. It's a bank between the seller and the buyer in LC. So it's the same concept. They are not a part of the contract of carriage. They are not original parties of the contract. A bank is not original.
One has possession, must pledge.
Has possession, but
They
that's
want,
yeah.
they got constructive possession of the car. It's as if you put 50 tons of grain into the bunker.
Yeah, but they cannot go to the carrier and they don't have a title in them. If they don't have a title, because if you already, it's already endorsed to the consignee. The bank is not the consignee,
It's pledging.
No, but it's,
It has pledge.
but it doesn't have.
well, presumably it's the consignee who's actually pledged bill of lading to the bank.
But can bank go to the carrier and demand the goods?
But yes, but it's a loss, we want.
They don't want to get it.
But they find it. And they might use that.
But it's not, but it's not endorsed, and they just have possession.
It doesn't need. They've got, possession is being given to. I mean, you could endorse, but it just, there's no votes. There's a security, it's an old fashioned form.
Yeah, okay, but what you said by so there, you already have this different parties entering into bill of lading, like you mentioned with the promissory note, bill of exchange. So it's possible.
I think perhaps we have a similar problem to the property law problem I mentioned, that we are beyond the scope of this legislation. And we'll also exchange, so for example, we also have the problem that some states are parties to the conventions of this. But UK is not, they use the common law system. And whether or not a notary will accept an electronic document will depend on the conventions, and it will depend on the procedural law, which has not been addressed. I thought perhaps that, for example, the protests or promissory notes and bills of exchange were not very common these days. But that's it. We don't teach it anymore in Norway. We have some acts. But if I may, I'd like to refer to the other question that was raised about using electronic documents to get control over immovable rights. I think that's quite interesting. And we have to remember here which problem documents can resolve in different jurisdictions. And English law is very, I think, colored by the problem they envisage that you cannot transfer property just by assignment. And that's why you need a document of title, because you have a document, and then we don't have only a simple assignment. We can transfer property by and this is why a bill of lading can transfer property, not because the master has decided who has the property, but because we can resolve this assignment problem. That has been, however, in English law resolved more generally recently. And in other jurisdictions, we may not have the same problem. Their documents may represent something else. And the Scandinavian documents, the main problem there is the possession of a document gives a better right than the person who had documents previously. And that's a completely different story. And we all confuse this when we discuss the different documents. But in English law, the problem, the basic problem is to assign property. And I think one can do that now without documents. Certainly, that problem can easily be resolved by saying that if you have electronic control, that will give a right of assignment, just as well as, for example, a document.
Again, just a few comments. Starting with Professor Thomas, you mentioned that they may not be necessary to have bills of lading. You're completely right. About 50%, even more than 50% of trade of all transportation, there is no need for bill of lading. Bill of lading is necessary when you want to transfer rights in the goods in transit. You mentioned oil. Sometimes oil is resold many times. In that case, you need bill of lading. Otherwise, in many trades, you don't need a bill of lading at all. And that leads to the problem that you raised, and thank you for that. That's very important that I want to mention something. Delivery of the goods without bill of lading. This is serious problem. Why? Because the ships became faster. Cargo handling, particularly containers, faster. So the ship is already at the port of destination, but bill of lading is not there. And then you have a problem. So what to do? Of course, you cannot deliver without bill of lading because that would be fundamental breach of contract. It can be tort, as Professor Thomas mentioned, tort in conversion, can be contractual, fundamental breach of contract, which means that you cannot get even reimbursement from P&I Club. They would have refused. Why this is important? Because actually, this is the problem that is the most crucial problem for electronic documents, trade documents. You don't have this kind of problems with bills of exchange. I have a colleague at NUS. Students have no interest in bills of exchange anymore. The problem which arises in practice is this. The most crucial core issue that arises, what happens in practice is delivery of the goods without bill of lading. And electronic bills of lading will solve the problem. I mean, like that. You don't have this kind of transactions. You transfer, you use a DHL, whatever, but it takes time, no? And by having actually all these documents that are mentioned in these trade documents, the core issue, the core document is bill of lading. That is the most important issue that arises in practice. And Eric, as I mentioned, bill of lading can transfer, may not transfer property. It depends. If you have legal title, of course, with transfer bill of lading, you have a transfer property. If you don't have, as I mentioned, this case from Japan, you are just agent of the owner, then you don't have transfer of property by transferring the bill of lading. So it's in principle you can, but not always. Depends on whether there is a legal basis, contract of sale, of course. I'll continue with a few more slides. Thank you for contribution.
Can I just clarify?
Yes.
The English position. It's not a document title. In concrete, but you say title, that triggers concept of ownership. It's not a document title in that sense. So it's misleading. It's all about possession. But the intention we got under the insurance passes under the contract of sale. The intention is that title passes according to the time and place the parties intended. The bill lady may be very good, because they could agree that title in our contract will pass with delivery of bill lady. You could have a packet of cigarettes for the bill lady, same effect. So, and in other legal systems, they can work differently. So the tax rate is highly variable. And to think about, I mean, and therefore it is also not a negotiation. But as a bill exchange, so it is taken at any point. Like in a negotiation instrument, a 45-year transferee to take a better title than that possession by the transferor. That doesn't work. If you try it, if you go back 100 years, if you say, this is a negotiation, so I take it, no. So it's actually title is governed by the law sale, and the bill of lading plays a big part in that. So it goes back to the point I made that we have all this elaboration around the bill of lading, and it's all kind of part of the outer solar system. You know, the bill itself, at the heart of it all, well, it's a very historic document, and it's very important, but it's significant. It's much more limited.
Yes, actually, maybe Peter may remember that I always warn students, when you say document of title, title does not mean property. It means a title to receive the goods, not property. But property eventually can, with legal title, legal basis, you may transfer property. But as I mentioned, the one who issues bill of lading is a carrier. He cannot certify who is the owner. So it's not a document of property.
But even to transfer, sorry, but I mean, in delivery, the right to receive is very important. Right? Because the master, at the end of the day, has got it delivered to the party who is entitled to the car.
Yes.
And the person with the bill of lading may not be. And so the master has to exercise reasonable care. It's in a very difficult position, to check. Right? I mean, you have an old case of $40 billion worth of oil coming out of South Africa to China. And they had electronic version. And they created forgery. And the forgery, they signed the master's signature. So the master got into the Chinese terminal and said, "Give me the bill." And he looked at the bill, fine, gave delivery. It's total forgery. Liability, PLI, $14 million. Because it went into the tax and disappeared in the distribution center. So, in those circumstances, must have done more, but he had misdelivered. And there's just a hint, because that wouldn't be covered. The very, very sensitive about bill of lading and how it's translated. But there is a hint that they would give some conversation with the discussion point.
Dear friends, we are running almost 45 minutes late, so we are back in our good old. I feel so bad about cutting discussions because that is what this course is all about. I mean, this is excellent. I would like to say, let's go for another hour with this discussion, but we still have two lectures in this session, and Professor Časlav has to wrap up his. So
how many minutes do you have?
You'll have finished. Try to wrap it up in 2 minutes, okay?
Okay.
And then we'll have two lectures and maybe some discussions.
Okay, these are something I already mentioned about trade documents. What are trade documents? And yes, I mentioned that.
You have too much time.
Yeah, I just mentioned the problems actually arise in case of bills of lading, not in other kind of documents. So it's actually that is the most important point.
Yeah.
What are trade documents? You can see that there are differences. Under UCC, bills of lading, dock warrant, dock receipt, warehouse receipt, order, the ship's delivery order. UK bills of exchange, promissory notes, bills of lading, ships delivery orders, etc., etc. French law, you see discrepancy in all these documents. So there should be some need for clarification. What are trade documents? And so far, there is no definition of trade document. This is a new term because we have document of title, we have negotiable instruments, negotiable documents, but trade documents is a kind of new term. So this would also need the clarification. Okay, yes, I'm raising some issue about English law. Is trade bill of lading document of title under English law? Under COXA 1971, it is similar document of title. Under COXA 1992, it's not. So it is both document of title. Can it work? I think law commission should do something about this because they cannot have two meanings of the same document. Receipt for shipment. I mentioned already multimodal transport document. Also, I mentioned about the mate's receipt. I don't think it's trade documents. Looking for the future, English law will have strong impact because of role of English law it has in practice. So now the issue is whether there is a need to clarify what is the concept of control. I think that would not be easy, but I think if you want to use this term as I think Eric mentioned, it's about terminology. You should clarify what does it mean. At the moment, it means different things. Okay, so what is essential is to achieve the same result, not necessarily in the same way. So I think both can work. English approach can work. Other countries can work, but and I don't think there is a kind of that conflict that cannot be reconciled. You can have both ways coming to the same goal, and the future will be digital. So try.